Hi, my name is Emily Paul, the District 504 Coordinator for the South Carolina Public Charter School District, and we will be conducting our annual 504 training for school level 504 coordinators. I want to make a point of saying that what we are talking about today is not special education. The responsibilities for 504 do not fall under special ed programs or IDEA. It is a general education responsibility. Charter schools have a lot of autonomy. However, when it comes to 504s, there are a lot of things that our charter schools need to understand. First, they're expected to follow the District 504 policies and procedures. These procedures include the identification of the principal or his or her designee as the Section 504 school coordinator, who's the building level compliance monitor and coordinator for Section 504 support. The district Section 504 compliance officer is Emily, me. The district Section 504 compliance officer cannot serve on school 504 committees because I'm a part of the district's grievance process, and that would be a conflict of interest. If you're watching this training, you've probably been named as a school's Section 504 coordinator. Let's talk about your roles and responsibilities as a 504 coordinator. Your roles and responsibilities include convening Section 504 team meetings, providing guidance and answering questions surrounding 504 referrals, evaluations, implementation from parents and guardians, students, and/or staff, reviewing physician statements and contacting the student physician if additional information is needed, scheduling and sharing meetings with parents and guardians and relevant school staff, and maintaining school-level 504 files for each student. My responsibilities as the District Section 504 coordinator or compliance officer are understanding the requirements and intent of Section 504 regulations, establishing and monitoring Section 504 referral identifications, reviewing processes and procedures, including annual notice, maintaining data and preparing annual reports on compliance, developing awareness materials and workshops for school staff, implementing Section 504 complaint procedures, conducting self-reviews, and serving as district liaison to the Office of Civil Rights. So, what is Section 504? The Rehabilitation Act of 1973, commonly referred to as Section 504, is a federal statute that prohibits discrimination against persons on the basis of their disability by institutions that receive federal assistance, such as schools. Section 504's purpose is, among other things, to assure that students with disabilities have educational opportunities and benefits equal to those provided to non-disabled peers. If a student is covered by Section 504, South Carolina Public Charter School District schools must provide protection and accommodations as are necessary to ensure that the eligible student has equal access to services, programs, or activities offered by our schools. We're going to go through a couple of examples of students that could have had protections under Section 504. This is not meant to be generalized, so not every student with a disability would have this protection, only those who would have protection under Section 504. I'm just going to give you a minute to read these examples. So again, Section 504 is not IDEA or special education. When you put expectations of each side by side, you'll see the differences. So you'll see under IDEA, students must have a disability that falls into a defined qualifying area and adversely affects educational performance. In Section 504, a student must have a physical or mental impairment that substantially limits life's function. In IDEA, a student needs specially designed instruction. In Section 504, it's meant to prevent discrimination and ensure equal access and accommodations and services. IDEA requires a comprehensive evaluation, including screening, psychoeducational evaluations, and intervention data. Section 504 requires relevant information from a variety of sources. IDEA, the criteria of exclusion or narrow eligibility, and that works really well with RTI. Section 4 has broad eligibility, and it does not work well with RTI. IDEA has defined IEP team members, where Section 504 includes a group of knowledgeable people. For IDEA, parental consent is required. Section 504 is not, parental consent is not required, but is strongly recommended. IDEA has strict and specific timelines, whereas Section 4 has reasonable timelines. Here's a good visual starting with your general education population to show how students might be eligible for IDEA or Section 504. The largest circle would be your general education population. Then inside you have students with disabilities. Not all students with disabilities need accommodations or services, but some do. Those that do may only need accommodations to access their general education curriculum, and they might fall under Section 504. Others may be specialized instruction and services paired with accommodations, and those students would fall under IDEA or special education. An important thing to realize is that you can't have both during the same school day. You can't be a student who is found eligible for special education and have a 504 plan, because special education services and accommodations would be all-encompassing of a student's needs. There are some very rare situations in which a student might have an IEP but need a 504 for activities outside of the school day, such as aftercare, but there are some very specific guidelines for those situations. Let's talk about the referral process for Section 504. This can happen several ways, one way being a transfer from one school to another. Also, a parent, school staff, or adult student may refer someone who they believe has a physical or mental impairment that substantially limits one or more major life activities. A child will not go through the RTI process when being referred for 504. This is something you should educate your staff on and build a process for. Think of a situation where a parent emails a teacher at the beginning of the year to share that their child has ADHD and is on medication. The response should be, "Thanks, is this something you just wanted to make me aware of, or do you think the child may qualify for protections and accommodations under 504? So let's talk about the example I just gave. A parent notifies a teacher that their child has ADHD. The school needs to have a process to identify what to do with information like that. Step 1 would be to ask the parents if they're just wanting to make you aware, or if they would like the school to take action, depending on the response. You may need to convene a 504 team meeting. Before we talk about specific eligibility requirements, let's talk about who usually serves on a 504 team. All decisions regarding 504s are made with a 504 team. There is no regulation that describes a minimum requirement of team members, but when you think of a team, it should include the 504 coordinator, the parent or adult student, and relevant school staff. So what's relevant school staff? A person who is knowledgeable about the child, a person who is knowledgeable about the meaning of evaluations that may have been conducted, a person that is knowledgeable about accommodations or placement options, and possibly a school psychologist. The 504 coordinator is a required team member for all initial 504s, but does not necessarily need to attend for meetings beyond the initial meeting, so long as the rest of the committee has 504 knowledge. Unlike IDEA, Section 504 does not have a specific criteria for eligibility or specific components recommended as part of an evaluation. Under Section 504, evaluation does not mean a formal battery of assessments. What's required is data from a variety of sources. For example, a note from a doctor about ADHD with classroom samples or behavior charts. That might be enough to be able to make a link between the disability and how it impacts a student at school. Failing grades are not required. So just because a student has straight A's and is doing fine does not mean that they don't need a 504 with or without an accommodation plan. What you're looking for is evidence of a physical or mental impairment, and then evidence about how that substantially limits the life function of the student at school. There is no set criteria. You have a lot of flexibility at the school level on this. So you can get data from a variety of locations. You can get student grades, disciplinary referrals, health information, parent information, test scores, teacher comments, special ed assessments, and data. The amount and the weight is determined by the 504 team given the student's individual circumstances. So in some cases you might really weigh teacher observations, where in others you might really weigh student grades and ability to focus. They also can include screenings, but those are not required like they are in IDEA, so you don't need to jump to a vision and hearing screening right away. And no medical diagnosis is absolutely required if you have other data. While it's easy to qualify under 504 if you have a medical diagnosis, it's definitely not required. So as long as you have other data that supports a mental or physical impairment that limits the life function of the student, that student will qualify under Section 504. So eligibility is a three-part process for the team to decide, and I'm going to state or reiterate that it's a team decision. Step one is to determine if a student has a physical or mental impairment. If the answer is no, then the process stops there. If the answer is yes, then the team needs to decide if a major life activity is impacted. If there aren't any, then the process stops there. Step three, you need to determine if the impact is substantially limiting. The courts have made it really clear and refused to give a definition of what is substantially limiting. The important thing to understand is that you can have a child who has a mental or physical impairment that does not impact a major, or that does impact a major life activity, but does not substantially limit that activity, therefore would not need an accommodation plan. That would be a child who would be 504 eligible, but without an accommodation plan. I'll break the process down a little more, but please know that everything you need to know is located on our bookshelf under Section 504. Let's talk about parent requests. The parent or adult student requests a 504, they should be directed to the school's 504 coordinator immediately. Then they'll complete the referral section 504 during an interview with the parent or adult student. They'll also provide the parent or adult student with a copy of Section 504 rights. A meeting will be scheduled with all relevant staff and parents, and a Section 504 meeting notice will be sent. The 504 coordinator will coordinate the data collection and preparation for the 504 meeting, and again, these forms can be found on the bookshelf. School staff requests work in the same way, but the coordinator will complete the referral form with the staff member rather than the parent. Once the referral has been complete, the school should contact the parent to discuss the concerns and to schedule the meeting. When a staff member refers a child for 504, there's usually been contact beforehand about the concern. So it shouldn't be a surprise to a parent that this teacher has concerns. The meeting notice for the 504 meeting should not be their first indication that there's a problem at school. When a meeting is scheduled, you'll send the parent their 504 rights and begin coordinating data collection. During an initial meeting, you'll work your way through the initial 504 meeting paperwork. You've got your referral data, and you will gain parental permission, but again, it's not required for a 504 evaluation. At this meeting, you'll make one of three decisions. One, do you have enough information to determine eligibility? If yes, does that child qualify? And if not enough data, get permission to evaluate, which again is not required but strongly recommended. If there's no additional data needed, this is page 2 of your form. You'll take the team through the questions on the form. And so there's the initial evaluation and periodic reevaluation form. There's a 504 plan, and then you're going to ensure that the 504 parental rights have been provided to the parent or guardian or adult student. If you need to gather additional data, parent consent is not required, again, but we strongly recommend it. You need to decide what you need, who's going to gather that, and what your timeline for gathering that is. Once you have the information you need to determine if the child qualifies under Section 504, you'll make the decision with your team. You'll walk through the questions. What mental or physical impairment does the child have? This is not where you're going to question the note from the doctor, so you're not going to wonder, okay, we have this doctor note that says ADHD. Do they really do a battery of tests? That's not up to you to decide. What is the life activity that the impairment affects? And then question number 3 is is important. How does the impairment substantially limit the child's life function? What is the threshold for substantially limit? Again, we don't have a clear definition, but the decision must be made on a case-by-case basis by the school team. Teams should always err on the side of inclusion and eligibility. A disability is not substantially limiting if the student is successful as typically developing students in major life activity. And a disability may be considered substantially limiting if it prevents the student from participating in the same activities as other students. A big topic surrounding 504 accommodation plans is mitigating measures. Mitigating measures are devices or practices that a person uses to correct for or reduce the effects of that person's mental or physical impairment. An example would be a child with ADHD that takes medicine. When the child takes their medication, their behaviors are controlled. That child's ADHD does not substantially limit their life function because of the mitigating measure, so they may qualify under Section 504 protections, but they don't need an accommodation because the mitigating measures of the medication. Mitigating measures should not be considered during 504 eligibility. One mitigating measure that the law has said may be considered is eyeglasses. So back to the referral process. You're on step 3 of determining eligibility accommodation plans. Does a child need 504 services or 504 accommodation plan to meet their needs or to prevent discrimination? The team would then develop the accommodation plan that includes statewide testing accommodations. These should allow the child to have the same equal access as their non-disabled peers. Accommodations are not a buffet. There should be a link between the instructional accommodations and assessment accommodations, and there should be a reason for each and every accommodation. There is a big difference between it will help him and he needs it to level the playing field. Be thorough and thoughtful when you write accommodations. After the meeting, communicate the results of the meeting with all relevant staff that would need to be involved in the area that the child is accommodated. The involved teachers should all sign that they have received a copy of the 504. The 504 files need to be stored somewhere securely. This should include all 504 forms, data, and receipt of accommodation plans. We're asking that you keep a folder for each child with all the appropriate documentation in a locked file cabinet. That way, if for whatever reason I need to view a 504, I can call you, you can email it to me, and I can get whatever information I need. Storage of these files are bound to the same retention policy as any other educational record. There may be a time you need to discuss discipline and a student with a 504. If a child has been recommended for expulsion or long-term removal for more than 10 days, a 504 meeting needs to be held to determine if the behavior is a manifestation of the student's disability. All these procedures apply except students with 504 plans do not qualify for alternative education setting services. If the behavior or incident is not a manifestation of the disability, appropriate disciplinary action can proceed and the student can be treated like any other non-disabled student. If the behavior or incident is found to be related to the disability and the student will be over the 10 days allowed, the school may not discontinue educational services. This means that the student must be returned to the regular education program in which he or she was enrolled. In addition, a reevaluation must be initiated to determine the need for additional accommodations under Section 504, which may include a behavior plan or evaluation for eligibility under IDEA or special ed. Current drug and or alcohol use or sale automatically ends 504 protections. So what do you need to do now? For those of you that are new, you need to obtain all student files and review the list of students to ensure you have all files for your students in your building. You may need to work with the person who served as coordinator last year to do this. There's also a Field and Power School that's required and asks about 504 students and what major life activity is impaired. Make sure that you're working with your Power School staff to update them after you've had 504 meetings. Also make sure your staff understands what the accommodations are for each of the children. This should take place before school, but with turnover of staff and release of training, that may not have. If it hasn't happened, go ahead and do that now. All students with 504 plans will have an annual review each year before the end of the first 9 weeks. Students who are 504 eligible have ever-changing needs and requirements, and plans should be modified based on those needs. Changes, even if they're minor, document that the case has been reviewed and the student's needs have been considered by the 504 team, at least annually. If a student has recently received or is suspected of having recently received a Section 504 support out of our district, then a referral for Section 504 services must be initiated. Pending the completion of an evaluation and final determination of the student's needs for an annual Section 504 accommodation plan, interim Section 504 services may need to be implemented for the student. When a child transfers, we do want you to go ahead and reestablish eligibility for needs in your environment, and it's fine to provide an interim plan while reestablishing that eligibility. So this talks about how you're going to do that. You're going to acquire all the records from the previous district. You'll hold a planning meeting to determine all the same things that you would do for an initial eligibility meeting. Every few years, a reeval needs to be conducted. Again, this is not a formal evaluation process as it is with IDEA. This will also be done if a child needs to be exited from a 504. It will look the same way that an initial evaluation would look. You'll gather your team members, you'll review the data, and you'll determine eligibility. A student may only be exited from Section 504 under the following circumstances. One would be that it was a temporary impairment which had educational implications for the student, such as injury sustained from an accident, and that would be no longer present. The second would be the student's disability no longer substantially limits his or her major life activities, or the third would be the student has been identified as eligible for receiving special education and related services. And obviously sufficient documentation is required to complete the exiting process, which would be a reevaluation. There are situations out there when a child needs more than a 504 plan to receive a free appropriate public education, or FAPE. Keep in mind that if a child's needs are so significant that they need more than a 504 to access their curriculum, then you do have a responsibility under Child Find to refer that child for special education. If you have a situation like this, please talk to me, as special ed falls under my duties as well. Remember, it doesn't matter if a parent doesn't want a label. It's the school's obligation to refer for special ed when needed. So a 504 plan, if you are going to refer a child for special education, a 504 plan would not be developed at that time. Remember that a 504 accommodation plan is a provision of FAPE. If services under IDEA are needed to provide a FAPE, then FAPE cannot be lessened to what a 504 can provide. Revocation of services under IDEA does not automatically equal the entry to a 504. When someone feels their child is being discriminated against based on their disability, you need to handle that at the school level. You don't want to have a parent go to the Office of Civil Rights because you haven't taken them seriously at the school level. Make sure there's a process in place to do this. Step one would be have a process to investigate at the school level if there's a complaint from a parent or adult student. It should be a written complaint. It can be an email, or there's a form on our website, and it should be resolved within a few days as to not let the process drag on. Once a written complaint has been given to the 504 facilitator or principal, request that the 504 team review the plan and attempt to resolve the disagreement. The complaint should be handled again very promptly within 5 working days so that a response can be given to the parent. And then once a response has been given to the parent, you need to send me the written complaint and the response to the parent as soon as possible. Step 2, next, if it's not resolved, the complaint is filed outside the school level. It would go to our district office, then to our superintendent, the board, our district board, then to the Office of Civil Rights. While we encourage them to follow that process, parents can skip steps and go straight to OCR. Of course, we don't want that, so it's really important that you're listening to your parents and taking them seriously. Just keep in mind that any decisions made between steps 2 and 5, such as going to our district office, superintendent, our district board, and our OCR, the decisions made during those processes are binding to your school. So you really do want to attempt to solve those complaints at the school level before they go any further. Please, if you have any questions, direct them to me, Emily. My contact information is on the bookshelf, and then you have, I'm sure, copious emails for me. If you are in doubt, please do ask so that we can help guide you. My contact information is on this slide, and for accountability purposes, the code word for this training is enrich.